Welcome back, everyone, after lunch. We will start the afternoon session now. After hearing all the interesting discussion this morning on generative AI, this panel will focus on AI governance and regulation from industry point of view and also external law firms. Let me have a quick introduction of our distinguished panelists for this session. I will go by the order, the speaking order. So to my left, first is Chief Legal Counsel of Microsoft for the Greater China region, Winnie Yeung. Winnie helps the business and the customers on the cutting edge of business, legal, and regulatory issues to drive their digital transformation. She will be sharing with us on Microsoft's perspectives on AI governance today. To her left, we have APAC Head of Privacy and Data Policy at Meta, Raina Yeung. Raina is a former regulator at the Hong Kong Privacy Commissioner for Personal Data. She will talk about Meta's approach to building AI responsibility. Next, on the gaming front, we have the Head of International Privacy at Tencent, Timothy Ma. Timothy will discuss some practical tips on protecting the privacy of our future generation in the digital age of AI. Then the next one would be on the regulatory side, we have Special Counsel at Baker McKenzie, Dominic Edmondson. Dominic is a technology and IP lawyer focusing on AI, data, and trending technologies in Asia. He will give an overview on AI regulations in different jurisdictions. Last but not least, we have Samuel Yeung, who is a partner at AnJie board law firm. Samuel leads the technology, data protection, and the cybersecurity practice at AnJie with nearly 20 years of experience within the TMT sectors. He will speak about AI regulations in China. With such a fantastic lineup, let's start right away with Winnie. Thank you.
Thanks, Catherine. Good afternoon, everyone. I'm thrilled to have this opportunity today to share with you Microsoft's journey on AI governance. 2023 is truly an inflection point for the AI industry. ChatGPT has made it possible and accessible by the public to the technology. And we at Microsoft we are committed to bringing this technology to the users responsibly. This slide highlights why we should be thrilled about the promise of AI. We see a lot of potential and possibilities that AI brings. And like the internet and smartphones, AI will fundamentally reshape how we work and how we live our lives. We are already seeing some early cases of breakthroughs in different areas, such as healthcare, scientific research, and sustainability. And the growth of conversational interfaces will open up the benefits of AI to all across the society. As AI become a bigger part of our lives, we heard this morning that governments and regulators around the world, they are still working very hard to strike the right balance between innovation and regulation. And in the absence of clear policies and regulations, companies must chart their own path on how to develop and deploy technologies responsibly. And that's exactly what Microsoft has been doing. So we start our responsible AI journey back in 2016. And it was grounded on 6 core principles: fairness, reliability and safety, privacy and security, inclusiveness, transparency, and accountability. But it's not enough just to have the principles. We also need to operationalize these at scales. So, in 2019, we come up with our internal playbook, the Responsible AI Standard. It provides practical approaches to help us identify, measure, and mitigate harms in advance of times, and require the different teams in the company to make sure that we could take steps to secure beneficial uses of the technology and also to guard against misuse. And the AI standards are built on 3 pillars. First, we identify the different goals and requirements and practices for each of the standard. And then we make sure that we have the right processes, training and tools for our colleagues to implement these standards. And last but not least, we want to make sure that we have the right process to have oversight on the implementation through monitoring, reporting, and auditing. And as I said, the first version came up in 2019, and in 2022, we come up with version 2. And this is basically a rewrite of the standard based on our experience throughout the years. And it's important to note that, from our experience, it's very important to have a vibrant ecosystem internally to make sure that, these AI standards are put into action. So in Microsoft, we have different layers of the ecosystem. At the very top, we have our board to support us. And then we have Brad Smith, our president and vice chair, as well as Kevin Scott, our CTO, to be our executive sponsor. And we have created a dedicated Office of Responsible AI to help us come up with the practical guidelines so that each of our teams will know how to comply with these internal standards when they do research, when they think about policies and do their engineering development work. And while we are committed to be doing our part, I think many of you would agree that guardrails for governing the use of AI should have a broader sense of shared responsibility and should not be left in the hands of technology companies alone. And so in May last year, we released a white paper called the Governing AI, a Blueprint for the Future, which we sought to address the issues about how to best govern AI and our 5-point blueprint. I think at Microsoft, we believe that it is important that the government, society, and industry players all come together so that the laws and regulations that we come up with will be in terms of so that we'll be able to come up with norms and standards that can guide our responsible use. And based on our experience from identifying and addressing some of these AI issues, we believe that regulations should be risk-based, outcome-focused, adaptable, and aligned to international norms and standards. And as we integrate ChatGPT into our products and services, like Azure OpenAI and Microsoft Copilots, we continue our AI trust journey by introducing additional measures and tools to address our users' concerns. So let me take you through some of these. In May last year, we announced that we offer AI customer commitments to our users. By this, we are committed to share our learnings on responsible AI and our resources in this area with our customers. We also committed to create an AI assurance program to help our customers engage with regulators as they go through the AI transformation journey. And then late last year, we also introduced a copyright commitment for our customers. We also work with our partners to support our customers to build their own responsible AI governance teams. And based on our learnings from the financial services industry, where they have their know your customer requirement, we come up with a risk management approach called the know your 3C. And these threes are know your customer, which means that, we need to manage access to our AI data center infrastructure and models. Know your cloud, so that you will be able to understand the cloud security infrastructure to manage risks that threat actors may exploit vulnerabilities. And then lastly, to know your content, so that users will be able to identify what are the AI produced or altered images, like using tools like Watermark. And the theme for today's discussion is protection of personal data and AI. So let's double click on what Microsoft is doing in this area. Really need to double click. Okay, so first, I think just now we've seen that from the responsible AI principles, security and privacy are the core principles that we have already built into our standards. And we believe that that is definitely critical in building trust and in AI systems. We employ both security and privacy by design as we develop and deploy our AI systems. And we use different technologies and tools such as encryption and red teaming to make sure that our users' data are secure. Oops, sorry, back. Next, on transparency. We think that transparency is important to enable our users to understand the capabilities and limitations of our AI systems. And using Microsoft Copilot as an example, we have different channels of transparency notice to meet the users where they are. For example, there are disclosure and choices of interaction with AI so that the users would know and understand how to harness the benefits of the AI and also limit potential risk. And we also ground our AI outputs with information on the source of the outcomes and also source materials. So this will be provided real time to the users so they know the links of the public websites or access of the source of the documents, internal documents where they have been authorized to access. And this will allow the users to better evaluate the credibility and relevance of the outputs. Thirdly, we put user in control of their personal data, and we honor their privacy choices. Through the Microsoft Privacy Dashboard, our account users can access, manage, and delete any personal data, and also their stored conversation history. And last but not least, we're compliant with privacy and data protection laws in countries and markets that we operate. We engage with regulators to share information about how our AI systems work, how they protect personal data, the lessons we learned as we develop our security, privacy, and AI governance models, and also our ideas of how to manage the unique issues raised by privacy and AI. And we'll continue to engage and work with regulators around the world as the law develops and change. At Microsoft, we firmly believe that AI will play a critical role in helping us achieve our mission, which is to empower every person and every organization on the planet to achieve more. AI systems are complex and new, and we are still learning on how to best inform and share our latest and groundbreaking AI tools to our users in a meaningful way. So I'm really glad that we have this opportunity to have this conversation here today, and I look forward to continuing the dialogue with all of you. Thank you.
Thank you, Winnie. really impressed with Microsoft's strong commitment in privacy, data privacy, security, and transparency. So move on to the next speaker, Raina.
I want to thank the University of Hong Kong and PCPD again for inviting Meta to be part of this very important two-day event. And for today's agenda, I'm going to cover two topics. The first one is AI at Meta, how AI is being used at Meta. And the second is, while there's a lot of global discussions and global initiatives going on AI governance, I want to share from a business perspective, what we are doing before there are even the governance frameworks being put in place. So I'm going to use a real case study, which is our large language model, Llama 2, that we open sourced last year. I'm going to use that as a use case to explain our approach to building AI responsibly. Too short, sorry, I need to move this. So for a lot of people, I think AI has become a main sort of become mainstream last year after the launch of the ChatGPT in 2022. And a lot of people actually have been unknowingly interacting with AI systems before the launch of ChatGPT. But the ChatGPT is really the first time that a lot of people, they knowingly interact with AI systems, because people can actually interact with it and see how it's operating in action. But for us, AI has always been a very core part of Meta's system. So it's a critical technology that underpins everything that we do for over a decade. So let me give you some example how we use AI. So from the users, I think users, when they come to our platform, they can use AI to create avatars, and they can use AI to generate avatars, or they can use to create stickers. So this is how we are using generative AI on our platform right now. But other than that, we use AI on our platform to personalize people's experience, whether it's the feed they see, the content they see, and also the ads they see. So we use AI to personalize people's experience. And to our advertisers, and a lot of the advertisers on our platform are SMBs. And a lot of the advertisers, they find value in our platform because we use AI to help them to find the consumers who will most likely find the ads interesting and may respond to the ads. And a very important use of AI on our platform is really, we use it for safety and security and safety and integrity purposes to keep people safe on our platform. So every minute, a lot of people post all kinds of content and photos on Facebook or IG. And we rely on AI to help us find out the harmful content and to take them down. So to give you an example, our AI has improved so much that for harmful content, close to 99% of the content has actually been taken down, even harmful content or hate speech, even before a human being sees it. So AI is a very core part and important part in helping us to keep people safe on our platform. Now I'm going to turn to Llama 2. Llama 2, as I mentioned earlier, we open sourced it last year, but I wanted to start with walking through the journey or the memory lane about our responsible AI work. So we've got internally, we've got a fundamental AI research team. Internally, we call it FAIR. And they just celebrate 10th year anniversary last month in December. So our internal FAIR team comprises of AI scientists, and it was headed by Chief AI Scientist, a gentleman called Yeung LeCun, and he's one of the recognized AI godfather in the industry. So even before all the hype and all the news about ChatGPT, our lab consistently have been open sourcing different kinds of AI models and data sets for 10 years. So on the screen, you see some of those models. It doesn't make sense. Just look to me. I mean, I'm not a tech person, just looking at the number. But to people who are in the tech industry, for example, the OPT, it's called Open Pre-trained Transformer 175B. So it's a very important large language model. So why is people so excited about large language model is because historically, all this generative AI model, large language model is one kind of generative AI model. But before generative AI model, all the previous AI model, they are not trained with so much data. In addition, previous versions of non-generative AI model, the function is they're being trained to perform a very narrow and specific task. With large language model and generative AI, because they're trained on very large data sets, so people can actually use it and adapt it to too many different kinds of tasks. So for example, you can use the large language model to build a chatbot, or you can make it to build other kind of customer service assistant. So there's a lot more, potentially a lot more users. And there's already researchers out there using generative AI models to do antibiotic research discovery for medical purposes to solve all kinds of difficult societal challenges. And that's why generative AI is so powerful right now compared to the previous. And for OPT, it is the first large language model that's made available openly by any company in the world for free for the research community. So that was, we had a very long history of open sourcing our data sets and AI model. And I heard this morning someone was mentioning about sharing, and this is something that it's sort of in the DNA of Meta, because we have this very big research lab. And for the research community and the IT research community, open sourcing is something that's very common. And no language left behind is also another, I would say it's AI for good initiative. So our mission at Meta is to connect people. But for a lot of for the most common translation tool nowadays that's widely used by people, it has about 140 languages it supports. But no language left behind, it was able to translate 200 languages, including some languages that were not supported at all in the past. So let me give you an example. Wikipedia Foundation is using no language left behind the AI model to support the Wikipedia. So in Africa, they have this, I keep forgetting this language. They have this language that was being spoken by, called Lingala. It was spoken by 40 million people in the Congo, the Democratic Republic of Congo. But the Wikipedia articles available to 45 million people is a little over 3,200 articles. But then for the language in Finland, the Finnish language, which was spoken by 2.5 million people in Sweden and Finland. The Wikipedia has 10 million, and they have 10 million speakers. They have 2.5 million articles. So there's a very significant disparity from access to information perspective. So Wikipedia is using this large language model to try to bring more equality to people around the world, especially to support people whose languages are not as well supported and resourced by the popular translation tools. So and Llama 1 is the large language model that we made available to the research community in February last year. And after we released the large Llama version 1, we receive a lot of requests around the world from researchers wanting to have access to that. So let me give you another example. This is very new. It was released it's called seamless communication. It's also another breakthrough that I personally feel very passionate about. So seamless communication is in December when when our fair AI lab celebrated the 10th anniversary, they released this large language model they call seamless MFTV2. And this was recognized by the Times Magazine as one of the most important innovation for 2023. So for this seamless communication, so what happened is that it supports simultaneous translation function. So I was actually in Mexico in June last year, and I went on a local tour, and everybody on the tour at the tour groups was able to speak Spanish, except me. So what happened was that the tour guy, he spoke Spanish all the time, and then after he did all the introduction, and then he would pull me aside and then explain to me in English. So at that time I was thinking, oh, and I actually pulled up my phone and used Google Translate to try to translate it live, but it was actually very difficult. So I was thinking, okay, I hope there was some simultaneous translation too, and this seamless streaming is that. So what happened is the seamless expressive is a model that actually preserves the user's their voice and also your intonation. And seamless streaming it's actually a model enabling near real-time translation. So rather than waiting for you to finish the whole sentence and translate that, it translates in about 2-second delay. So if I tell you how powerful it is, it's a comparison with a UN interpreter. So this is something that we rolled out and also made available in December. And I want to talk about the benefits of open innovation really quickly, because I think in the policy circle, there are discussion about whether these powerful large language models should be open or should be proprietary. But for us, as I said earlier, we have 10 years of history open sourcing our data sets and AI models. And our view is that it's sort of in our DNA. And our view is that AI should benefit everyone, to benefit the society. And I think one speaker said this morning, actually, all this AI model is very, very expensive to build. And the computing power required is significant. And actually, I read an article a while ago. I can't remember the exact figure, but basically all the large language models available in the world, less than 1% is owned by non-private companies. So it speaks clearly that, I mean, it's very important to encourage the innovation to move ahead, that the large language model is open source, so that it's not just kept in the hands of a few large companies, and it can be used and tested and scrutinized, and with vulnerabilities and bugs identified, and so that a safety mitigation can be built, and all the risks about the model can be identified early, and the research community can work together to help build solutions to address this risk. And now I'm going to talk about the Llama 2. So I mentioned about Llama 1. So when we open source Llama 1 or in February last year, it was just open to the research communities. But we've got overwhelming demand from people wanting to use that. So we look at the risk, and we did a bunch of risk mitigation, and we decided to open source it to public, even on a commercial license in July last year. So what exactly is this large language model? So as I mentioned earlier, it's trained on a large amount of data, and we made available 6 different sizes. So the sizes is 7 billion, 13 billion, and 70 billion parameters. So the parameters means the concepts that the model knows. So we made available both the version and also a fine-tuned version. So for the smaller model, actually you don't need as much compute power. So people, if you have some computer skills, you can use it to adapt it to some use. For the larger model, like the 70 billion, you need a bit more resources and expertise if you want to use it. So these are some of the partners and supporters of the open source approach when we launched it last year. These are some of the people. And I want to talk about really deep dive into responsibility and how we identify the risk and the mitigations measures we took before we open source the large language model. So we have actually, when we launched the open source large language model, we released a set of documents, including technical documents, called Responsible Use Guide. We also release a model card and also release a research paper. So this is how the model card looks like. So model cards in the IT industry, it's a document that people will look at, and it will tell you about the use of that model and the limitations. We've also spent a lot of time before we open source a large language model to address some of the privacy and safety concerns that people may have. So for example, we have about 350 people, engineers internally working for 3 months to train the models. And we also do red teaming. Red teaming is, for example, we use a large language model and then we send in some prompts to the large language model and to look at its output, to see whether the output will contain anything that's problematic. So we've spent a lot of time doing red teaming. And we also, on the issue of privacy, to reduce the possibility of the model memorizing personal data about people, we spend a lot of time. So we remove, when we use the training data to train the data set to train the model, we remove the websites that has high density of personal information from the training data. For example, LinkedIn. Because we know it contains large amount of personal data. And we also train the model in the fine-tune stage not to respond to prompts to get people's personal information. So these are some of the things that we've done to try to mitigate the privacy and safety risks. And when we launch the Llama, we also launched a responsible use guide. So a responsible use guide is it helps the developers, because we have experts who ask us, so okay, you know how to do fine tuning, but when you open source the model, how about those people out there, they don't know how to do fine tuning and build in safety mitigation? That's why we come up with the idea to release a responsible use guide. So it is a resource for developers that includes best practices and also tell them how to do fine tuning. So people can go to the responsible use guide, and we have include in their best practices for people to create a data set to suit their particular task. And they can also give them guidance on how to do alignment. So for example, if you are a Japan-specific app developer, you want to develop an app for Japan, you can fine-tune it using responsible use guide to align with the values that you want to imprint in the model. So Llama 2 was developed from day one with privacy and safety mitigations in mind. Red teaming, I already spoke a little bit about red teaming, and we have internally, we have engineers doing red teaming. We also partner with external partners to do the red teaming and give us feedback. And we want to encourage the people to, we want to have diverse perspective and expertise. we want to bring together. That's why we accelerate the pace and the progress in AI research. We launch a program for academic researchers to design to foster collaboration and knowledge sharing in the field of AI. And when we open source Llama 2 in last year, we also announced a Llama Impact Challenge, and we'll be announcing the winners this year. So for the Llama Impact Challenge, we want to activate the community to use our Llama model to actually solve the hardest problems. So we have actually come up with 3 tracks: the education, environment, and open innovation. So the most compelling app, so we want people to activate the community to use a large language model to solve the biggest problems that the society is facing right now. The successful team will get $500,000 for the project, and we'll be announcing the winners this year. And we've also, and for generative AI, I think it was alluded to a little bit this morning. I think there's a privacy angle, there's copyright angle potentially. With so many different issues surrounding the debate, as a tech company and as a member of the industry, we think it's very important to be open about the work that we are doing and find ways to bring people into the process. That's why we've launched a community forum on generative AI, aiming at producing feedback on the principles people want to see reflected in new AI technologies. The community forum, we have already had a few sessions, and it was held in consultation with the Stanford Deliberative Democracy Lab and the Behavioral Insights team. And it's consistent with our approach to open collaboration to sharing AI models. So with that, that brings me to the end. And the last but not the least is we've also released a paper on building generative AI responsibly. And it's a resource that details the steps that we've taken to make the generative AI features safer. And if you want to understand a bit more about what I just said in the last 15 minutes or so, you can go and look for a lot more information in this paper. So thank you very much.
Thank you, Raina. Thank you for sharing Meta's different AI models and your openness in collaboration. Let's move on to Timothy.
Good afternoon, ladies and gentlemen, esteemed panelists and speakers. It's my pleasure to be here to be discussing this very important topic on AI, on gaming and kids. Thank you for Hong Kong University for inviting me to be speaking here and to fully embrace AI instead of using a Tencent template. I've used AI to prepare this slides. So I think, this is how we truly embrace AI over here. It's obviously the first session after lunch hour. Brilliant lunch. It was great to be, catching up with good friends, good old friends, and meeting new friends. Even though I know that as a matter of fact, this is going to be one of the best panels that you are attending in these 2 days. Let me first have a little bit of interactions with you guys. So I'm going to ask 3 questions and hoping that every one of you will be responding to my questions. So the first question is, how many of you have kids? Good. Oh, by the way, these are anonymized. I'm not collecting any information from you. All right. So don't worry about it. Secondly, out of those who have kids, any of your kids play any computer games? Console, mobile, PC? Excellent. Saving the best question to last. How many parents think that your kids are playing games secretly without you knowing? You're very honest. Yeah, it's great. So, we can really establish that, games is really part of our kids, daily lives right now. And, that is also why it is so important for us to discuss these very important issues on AI, on games, and on kids. Tencent, as many of you know, is one of the largest game publishers and operators in the world. We publish and operate some of the most successful games. And just to name a few, Honor of Kings, PUBG Mobile, League of Legends, Clash Royale, and many others. And at Tencent, similar to our fellow panelists have shared in their earlier presentations, we also take AI governance seriously and approach AI in a responsible, transparent, ethical, and accountable manner. I'm a very strong advocate as well that online service providers should also keep the best interests of the child as stipulated in the UN Convention on the Rights of the Child when offering their services to our future generations. Children should have the right to have access to all the wonderful services that are available online, but children would need to be enjoying these online services in a trusted and safe manner. So put simply, just stating that children under a certain age should not be using your services in their terms of service, in my view, simply does not work. And in fact, if you look at this issue from a legal perspective, there are many laws and regulations around the world that require online service providers to take extra steps to ensure that kids' personal data are being offered with special care. And sometimes parental consent will be required before any sort of processing of these children data. The UK Age Appropriate Design Code, the Irish Fundamentals, COPPAN in US, and many more. And in Hong Kong, the PCPT has issued guidelines on points to note for data users targeting children. And in Singapore, have issued a public consultation on the advisory guideline on the PTPA for children's personal data as well. And if you look at the headlines on many newspapers and news outlets, we can also see that there have been many enforcement cases around the world against different service providers for failing to offer adequate measures to protect children's data. All right, after setting the scene, one might then ask, how is AI relevant to gaming, and specifically relate to children's privacy and protection? Oh, sorry, wrong computer. So first of all, let's look at some of the AI functionalities in gaming. In fact, without probably you knowing or your kids knowing, AI functionalities have become increasingly prevalent in the gaming industry. Game developers are leveraging AI to create more engaging, immersive, and personalized experiences for players. AI is also being used for various purposes, such as generating realistic graphics, creating adaptive game levels, simulating realistic behaviors of non-playable characters, what we call NPCs, and even designing entire game worlds procedurally. Moreover, AI-driven systems help tailor game content to individual players, ensuring that the game experience remains enjoyable and in the kids' content be more age appropriate. How about the very hot topic of generative AI? I'm not sure if you heard enough or not, but I'm just going to go through this one last time in my slides. As a matter of fact, generative AI is being used in gaming in a much wider sense, and they are being used primarily to enhance gameplay and create unique experiences. So let me give a few examples. First, procedural content generation. Generative AI can be used to create endless variety of games accordingly. This ensures that the game remains challenging and engaging for players of all skills levels, providing a very personalized experience. So, for example, one of my favorite car racing games. The game may be adjusting, may adjust the performance of AI-controlled opponents based on player skill level. So I think, AI has been doing me a favor, making sure that, my opponents within the game are easily beatable. So thank you, AI. Realistic NPC behavior, just like what I've mentioned, AI can be used to create more realistic and dynamic behaviors for non-playable characters. This to make the game world feel more alive and more immersive as NPCs react to players' actions and the game environment in a more natural way. Lastly, in some of the very, very successful games in the world right now, they use AI to do interactive storytelling as well. Generative AI can be used to generate dynamic and branching narratives, allowing players to make choices that impact the story's outcome. This, again, creates a very engaging and personalized gaming experience as the story in the game actually evolves around the player's decisions. How is that related to kids? Are kids actively seeking out these AI tools in gaming? From our observation, whilst kids may not be explicitly seeking out AI-driven tools in games, we see that they're certainly enjoying the benefits of these tools bring to them in gaming. As I've mentioned, enhance the overall gaming experience, making games more enjoyable, more engaging, and more challenging. So as a result, games with AI-driven features tend to be more popular among kids, even though kids might not be actively aware of these AI components. These seamless integration of AI in games has made it an important aspect of modern gaming, and kids are naturally drawn to games that offer richer experiences and dynamic gameplay. So what are the risks associated with AI in gaming, especially for kids? I think, throughout the past few hours, we've heard a lot about privacy concerns. A lot of our esteemed panelists and speakers have spoken about how AI systems often collect data to improve their algorithm, to improve experience and things like that. And so, this could raise, issues about children's privacy and data security. Inappropriate content, AI algorithms may not always be able to filter out inappropriate content effectively. So, in a way, exposing kids to harmful materials. One of the very important aspects of, providing a safe environment for kids in gaming is look at how we tackle cyberbullying. Say, for example, in a lot of online multiplayer games with chat functions, these chat functions can expose children to bullying or predatory behavior from bad actors. Addictive behaviors, as I've mentioned, gaming that offers a richer experience often, attract kids to play them. And so, kids might be addicted to games or put it this way, more engaged with the games for a longer period. There are more and more, risks associated with gaming, with AI in gaming. But here I'm just going to speak about these four. So what are the best practices to mitigate risks associated with gaming or with AI in gaming? So at Tencent, we're keenly aware of these risks associated with gaming, with AI in gaming. And therefore, we have developed some of the best in class, I think, best practices to assess and mitigate these risks, to provide, as I've said, a safe and enjoyable gaming experience for our younger players. These would include content filtering moderation. I think one of the things that Raina has mentioned about content moderation, using AI will be able to screen a lot of content that could be unsafe to our children. Secondly, age verification and parental controls. I think one of the primary gaming companies are increasingly looking into age verification and parental control features to ensure that the games offer age-appropriate content to its users of different age groups. And the games that are offered by Tencent is no exception. These would include implementing age gates during sign-up process, offering parental control options within the game, allowing parents to set limits on gameplay time, restrict access to certain features, or disable in-game purchases. These measures help to ensure that children are not exposed to content or features that may not be suitable for the age group. And in my view, this also brings a very important aspect back into our kids' life, which are parents' involvement. Parents are the ones who know the kids the best. And so they'll be able to understand what the kids needs, what are their digital maturity, what's the culture is look like. And so, these, parent features and age, parental features and age verification will be incredibly helpful to bring parents back into the picture to make sure that kids will be able to get the appropriate guidance to explore the online worlds and explore the wonderful games that they have access to. Privacy and security and data security with AI technologies, it often requires access to user data for various purposes. At Tencent, we've prioritized privacy and security. And this involves implementing robust data encryption and storage protocols, as well as being transparent about how user data is collected, used, and shared. Our privacy compliance program also builds in protocols to ensure that we comply with relevant data protection regulations, such as COPPA in the US, GDPR in the European Union, the UK AADC, and other applicable children privacy laws. Ethics, being ethical in AI development is very, very important. We ensure that AI technologies that are developed ethically and responsibly. This includes addressing potential biases in the AI algorithms, ensuring that the AI generated content is inclusive and diverse. And we, as a game publisher, are being transparent about the use of AI in games. So how we achieve this is we look at the best practice in the industry, the G7 Hiroshima guiding principles, the ISO 23894 standards, the NIST AI risk management framework, IMDA's model, AI governance framework, and many other standards. We formulated internally a very clear guideline on how to develop AI in an ethical and responsible manner. And most importantly, it's just not a piece of paper that is being stored on our intranet, but in fact, we also provide clear guideline and practical guideline on how the document can be put at work. And so our AI product managers, our AI system developers, our AI data users, and our data privacy teams will be able to properly assess the risk of AI systems and features from the very get-go on the design phase to the actual deployment and the use of these systems. So we ensure that privacy by design and default is being implemented in any AI systems and features that we have. Education awareness, at Tencent, we also provide a lot of resources, such as guides, tutorials, and we offer these to our users such that they'll be able to understand how AI is being used in the games and how to stay safe when playing these games. We conduct risk assessments, and it's not just when an AI system is being developed, we conduct risk assessment. We actually conduct a regular one to make sure that we, as responsible gaming companies, that we offer a safe and responsible use of generative AI in our games, especially those targeted at children. We collaborate with our peers. We set up industry standards with different stakeholders to make sure that we are always, best in class, best in the industry, so that our AI system will not be causing harm to our users. So in conclusion, we at Tencent takes a very proactive approach to AI development and deployment. And we take an approach to assess and mitigate risks posed to children by AI technologies. And by implementing best practices, like what I've just mentioned earlier, we wanted to make sure that our games provide a safe, enjoyable experience to our younger users. Thank you very much.
Thank you, Timothy, for sharing your risk mitigation practice in the gaming industry to give parents a peace of mind. Now let's hear from Dominic.
Good afternoon, everyone. My name is Dominic Edmondson. I'm Special Counsel at Baker McKenzie. And I don't want this to turn into your afternoon nap. I'm just aware that we've heard from some really fun, about some fun products from some industry players, and I'm about to turn it back to the topic of regulation. For those of you that weren't fortunate enough to be at this morning's session, I think that Professor Chandra and Professor Yu did a very good job of sort of contextualizing some of the concepts that go into thinking about regulating AI from a privacy perspective. And we also heard from some of the regulators as well in other jurisdictions as to their approach and what's going on. I don't propose to recap what they said. And I also don't propose to do a deep dive into what's going on in China, because I know Samuel is going to talk about China in more depth a bit later. But I wanted to take a comparative approach and summarize the trajectories that different jurisdictions have embarked on and how to sort of conceptualize them. So what you can see from this horrendously complicated map, it may be something that's familiar to you if you're a privacy lawyer and you're looking at sort of comparative privacy regulations around the world. Okay, so we were looking at this, say in sort of 2018 when the GDPR in the EU was published, and we were doing comparative view of all the different sort of privacy laws that have been published or promulgated around the world. That map now looks a lot busier, okay, nearly 6 years on. And this is just the start for AI. And there's a range of different approaches to regulation. So I first wanted just to think about the parameters that are driving regulatory design. I mean, obviously, let's jump in at the sort of the point around data protection, because this is what the theme of the conference is. So AI crucially depends on large volumes of high quality data, and the model accuracy and the outcomes directly reflect the data it was trained on. And so data regulation, including personal data regulation, is central to AI regulation. And we can see that AI likely magnifies data privacy concerns, and we've talked about those issues already. But there are other parameters as well driving regulatory design, and in no particular order. International harmonization, for example, nearly every country has its own debate, and it's this debate again around rights versus legitimate interests. It's a debate around sort of major threat actors versus the potential benefits of AI. National rules conflict, as they do at the moment, for example, between intellectual property and antitrust or competition. There are signs of some attempts towards harmonization, such as Timothy referred to the G7 Hiroshima AI process, the OECD AI principles, and the UN AI advisory body. And there are also international technical standards such as ISO and IEEE. There's also an encouragement in some quarters to open AI innovation as well, which Winnie referred to before and Raina referred to. Now, aside from that, there are also the needs to address transparency, fairness, and explainability. And I think this is common to all regulatory approaches. Some also advocate a risk-based approach. So there are merits to this, but of course there are implementation obstacles, including how to define risk and how to measure it and what is legal and what is illegal. And then mitigating risk and the degree to which a potentially risky tool may be deployed because it's possible to mitigate a risk. And then there's a school of thought that encourages innovation and pre-approval. So the EU is an advocate of one of this, so seeking pre-approval to development of certain AI tools. Of course, the other side of that is the potential that this could discourage in some way or limit the ability of certain products to hit the market if regulation sort of front runs innovation. So, I mean, what we're looking at the moment is really a sort of a patchwork of laws that we have to consider. So existing law, obviously new laws coming in. We look at the EU AI Act, which is now reaching sort of the final stages of debate. Use case specific laws, for example, around employment laws, as well as data privacy laws, industry regulations, such as relating to financial services and healthcare, regulatory guidance, and then of course our sort of data privacy laws. Now, I think that if you look at this, if you look at this map, I suppose that we could sort of divide this into the spokes of this wheel into sort of three categories. One is enforcement and interpretation of existing rules. Another is new legislation, and another one could be said to be around standards development. And so together, these three categories, form potential for a framework for looking at AI regulation. So to some degree, I think all jurisdictions have features of these categories, regardless of their regulatory approach. And it's how regulators use such law, which gives rise to a divergence of approaches. So I'm just going to take a quick look by comparison between the EU, Singapore, Hong Kong, Japan, and also mainland China, just in brief to illustrate three approaches that have been taken. Now, these three approaches that I'm talking about here are essentially the comprehensive legislative approach, the precedent-based approach, and the control-oriented approach. So what we can see in terms of the comprehensive legislative approach, this is the approach that the EU has taken, which aims to be a world leader in the regulation of AI in the same way that it took the lead with the General Data Protection Regulation. And this essentially sets out a risk-based approach by differentiating AI systems into 4 levels of risk and imposing different requirements on each. So there are prohibited systems, which prohibit essentially those systems that manipulate human behavior affecting free will, social scoring, and certain elements of predictive policing or remote, including remote identification, biometric identification in public. So these are banned with a few specific exemptions for law enforcement. Then there are high-risk systems, which may involve, for example, likes of medical devices, law enforcement, administration of justice, and these have comprehensive mandatory compliance obligations with respect to, for example, risk mitigation, data governance, detailed documentation, human oversight, and transparency. They're also subject to conformity assessments. Okay, so this is the obligation essentially to evaluate how systems will comply with the AI Act with an emergency procedure allowing law enforcement agencies to deploy high-risk AI tool that hasn't passed a conformity assessment procedure if urgent. And then there are mandatory fundamental rights impact assessments, including rights of citizens to launch complaints about AI systems and receive explanations about decisions based on high-risk AI systems. Next, there are limited risk systems, and that includes chatbots. So those will have more minimal transparency obligations, including informing users, for example, that they're interacting with an AI system and marking synthetic audio, video, and text, identifying it as artificially generated. And then finally, all other AI systems not falling under one of these 3 main risk classes, such as AI-enabled recommender systems or spam filters, are classified as minimal or no risk. So the most prominent requirement under the AI Act is the requirement for transparency, which is familiar to data privacy lawyers already within the fabric of data privacy law. The assessment regarding, the conformity assessment should also ensure processes are documented so that regulators can assess the system's compliance, which means this is a to-market law, as in, for certain high-risk systems, you'd have to go through this compliance or this conformity assessment in order to launch the product. Now that concept is echoed actually in the interim measures for generative AI, which we've seen in China and some of the other rules coming out of China. Now, the AI Act isn't the only pillar, of course, the EU's comprehensive legislation approach. There is also, the existing, regulations such as the GDPR. We talked about automated decision-making earlier, and, how automated decision-making is specifically restricted if it's based on sensitive data, including personal data revealing racial, ethnic origin. So in addition to existing regulations such as the GDPR, which would require, for example, a data protection impact assessment, now players will have to go through an additional procedure as well for high-risk AI tools. So there's actually a layering of legislation to comply with rather than just, the obligation to comply with existing legislation. And if we move to the precedent-based approach, or rather, the sort of existing law-based approach. Now, I put Hong Kong, Singapore, and Japan in this category, but of course, their approaches also differ, as we've heard this morning. This is a more context-specific approach, relying on existing legislation supplemented by guidance. So in Hong Kong, as Commissioner Cheung said earlier, AI regulation may, in terms of processing of personal data, or rather will be subject to the Personal Data Privacy Ordinance. And she said that she is mindful of the risk posed by AI, but wants to keep an open mind and closely monitor the development of AI globally. Thus, the publication of the guidance on the ethical development and use of artificial intelligence in 2021, which applies to the development or use of AI systems involving the use of personal data. And this, essentially sets out high-level principles and guidelines to sort of moderate the same. And then the Hong Kong government, the Office of the Government Chief Information Officer, has issued an ethical artificial intelligence framework outlining 12 ethical AI principles that developers should observe when designing and developing AI applications. The point being here is that there's a recognition by the regulators and by the government of the role of private organizations and the private sector in certain, domains to essentially come up with their own governance standards and frameworks, and then also to come up with appropriate models for the development of AI. Singapore, we heard from Ms. Tung earlier as well, their approach consists of industry voluntary adoption with detailed government guidance. And so the Model AI Governance Framework is an example of this. Singapore also published other guidance notes and started other initiatives such as the Generative AI discussion paper, AI Verify, which is an AI evaluation and testing initiative in 2019, and also the more recent Generative AI Evaluation Sandbox in 2023. The point being that there's still subtleties of differences among these two jurisdictions, which derive their privacy laws from the OECD principles. Even though there may be many similarities between the Hong Kong PDPO and the Singapore PDPA, the way they conceptualize personal data differs as well. For example, the way that Singapore approaches business information or business contact information as not being subject to all the provisions of the PDPA, which is something that doesn't apply in Hong Kong. So regardless of the divergence of approaches in AI, this is nothing new. We've seen this already. We see this right now in terms of privacy regulation. And finally, in Japan, I just want to sort of call out what Mr. Asada of Japan's Privacy Protection Commission said this morning in relation to the Commission's letter to the OpenAI, which reiterated the need for proper notification and explanation to data subjects, and also caused OpenAI to translate its privacy policy into Japanese for more transparency. So we can see that regulators here are playing a role interacting with the private sector, reminding them of the obligations to which they're subject. Now, this is a jumping off point because the PRC is, I suppose, at the other end of this spectrum, if you want to call it a spectrum. This is a more reactive and control-oriented approach, generally speaking, and one key feature is specific regulations over designated AI applications. So the interim measures for the management of generative AI services and the administrative provisions on deep synthesis and internet-based information services, enacted over the last year, scrutinize generative AI technologies and also, deep fakes. And so these are specific verticals that it has been legislating in, which apply, again, which may prevent certain products hitting the market unless, for example, an algorithm has been filed, with the Cyberspace Administration of China in certain risky cases, for example, where something involves, a public opinion mobilization. So understanding, regulation from a governance perspective gives us a better picture. One imperative of China's leadership is to maintain social stability. And so, AI regulation in this sense serves a different purpose to some of the, the purposes or the parameters that we've been considering around AI safety or the protection of personal data subject rights. And so I think that just, as a comparison, I've put the EU approach here on the right. What you can see is that, there's the type of regulation involved here on the EU, it's legislative, whereas in other jurisdictions currently we're relying on existing laws. But there's an asterisk there because, of course, China has taken a slightly different approach in its vertical regulations. The prescriptive approach in the EU can be contrasted with a principles-based approach in other jurisdictions, particularly in Asia, and so on. And I think that one other thing worth talking about is that, under the EU AI Act, there is a proposal, for essentially a central AI office. It will be the European AI Board that will have the oversight over this. So you have not only the privacy regulators, but you have an AI regulator as well, which is something that other jurisdictions haven't adopted. In China, for example, it's the existing Cyberspace Administration of China that administers it. So I think that this is just up here for, for information as a sort of like a general sort of contrast. But if we look at some potential areas of convergence here, I think that there is a general requirement for businesses to assess and manage risk. So AI assurance and governance processes have become increasingly important as source of evidence that appropriate action has been taken across jurisdictions. Now, this isn't new. Even in jurisdictions where the GDPR doesn't apply, we see much guidance, and this can even involve sort of private sector, large companies, self-published guidance on, approaches to, privacy and also approaches to AI. The private sector needs to understand its leadership role in that case and enter into dialogue with data privacy and other regulators. There's also more of an alignment of rights and responsibilities. So under both EU and other approaches, customers have rights, such as not to be subject to fully automated decision-making, and businesses have responsibilities in terms of transparency and risk management, as well as potentially legitimate interests to be put into the balance. So how a balance is struck between rights and legitimate interests and the public interest will depend on the regulatory approach in question. And again, this is not new because this is something that regulators have been dealing with in relation to data privacy, as was touched on this morning. And a final point is that both government and non-government organizations are working to bridge the implementation gap by translating these high-level principles into standards documents. So it's likely that territories, jurisdictions would like to accelerate adoption while, maintaining their concerns about the risks that AI could have on individuals. The likely outcome of all this is what exactly? Well, it's likely a bottom-up patchwork quilt of AI rules. So the US, for example, is a decentralized and bottom-up approach that may have gaps and inconsistencies. And then, of course, you have a broad-based territorial approach to an AI law like the EU AI Act. This is unlikely in somewhere like the US, for example. So actions addressing sensitive areas such as healthcare, financial services, workforce practices, and child safety are more likely in a federated system such as the US. And of course, in Asia Pacific, where we're talking about many countries and territories, a divergence of approaches is likely to continue. Private AI companies will advance their own, responsible AI initiatives to serve customers. And there is a question mark over, or a division of opinion over whether this is sufficient really to address the dangers. And then obviously there are geopolitical aspects, which Professor Chanda referred to this morning, around trade conflict, a fragmented global regulatory environment, the splinternet, and so on, which we cannot avoid when we're looking at this area because there are so many parameters driving regulation. So growing competition, for example, between the US and China overshadows this AI regulatory effort because, well, essentially some of the policy initiatives that it comes out with, and both countries come out with, such as the protection of personal data and overreach in terms of cross-border data transfers, are likely to expand over time rather than retreat. If we look at other parameters, driving regulatory design, we can look also to the sort of sector-specific, the debate over sector-specific laws versus existing laws versus the new overarching laws. and the issues around regulatory capture, such as the ability of larger organizations to comply with overarching AI laws and the difficulty that SMEs, for example, may have in doing so. This debate is likely to continue for quite some time. I just wanted to set the scene before I pass over to Samuel to talk more in depth about China. But I hope that gives you something to think about as we go into our tea break a bit later, and more importantly, our debate.
Thank you, Dominic,
Thank you
for sharing different approaches. Let's hear from Samuel.
Good afternoon. Thank you, Dominic. It's a very interesting observation, and it's a very impressive categorization of the different approaches in different countries towards AI regulation. It's my turn to talk about some specific aspects of Chinese law in the AI area. Generally speaking, we do not have a AI law, already, but China has in the past few years issued some very special regulations to cover some very specific issues in relation to AI. And there are, of course, other laws and regulations, for example, cybersecurity law, personal information protection law, computational law, etc., to supplement other aspects in relation to the topic of AI. And China has also set some goals in terms of legislation plan, and by 2030, yes, and it's expected China will issue a more complete system of laws, regulations, ethics, and policies on artificial intelligence. And in between, by 2020, China expected to have some substantial capabilities in relation to regulating the AI and various other aspects in relation to AI. Essentially, those specific regulations or special regulations I just mentioned actually touched upon a number of special issues in relation to AI. But essentially, when you look at them, them all, and you have a general feeling that Chinese regulator is expecting operators of AI or providers of AI technology, etc., need to establish a responsible AI governance regime within the organization. And of course, that regime or framework covers a lot of different factors, as we discussed it already, including things like IPI protection, including things like privacy concerns, etc. But today, I'm going to only touch upon a few points. The first one is algorithm security, or the safe algorithm, and China's approach to the safe algorithm is clear. Number one, certain algorithms need to be filed with the government. That's number one. Number two, algorithms need to be subject to security assessment of the government. Of course, certain algorithms, and that standard itself is broad, as you can see. So basically, if the algorithm can affect the public opinion or has certain social mobilization capability, then potentially such algorithms will be subject to the filing requirement as well as the requirement of security assessment. And this may potentially cover deep synthesis, generation, or generative AI, personalized pushing, ranking and selection, retrieval and filtering, dispatching and decision making, etc. So this scope can be very broad. The government also wants transparency in relation to AI, and it does provide right to the individual to access to some important information of the AI technologies provided by companies, including, you need to demonstrate the final numbers that you have already acquired from the government. You also need to explain your principles of your algorithm, and the users may opt out of receiving personalized content or change their own tags. And the government will also periodically disclose information about the registered algorithms, including some specific aspects of such registered algorithms. Speaking of the APAC, China issued in 2023 issued the trial measures for the review of science and technology ethics. And just to be clear, this regulation is not just about AI. It covers a lot of controversial technologies. For example, genetic research. For example, to put human cells in animals' embryo, and things like brain machine interface or interaction, things like that. But among others, it does mention AI algorithm models, applications, etc. And essentially, this mechanism requires that the operators or providers of AI need to establish an ethics review committee and to put in place a framework, in terms of their rules of the review and their procedures, and the list of activities that need to be reviewed, trainings, a lot of aspects. Once again, it's not just about one exercise or single exercise. It's about a general, how to say this? It's more like an overall governance framework led by the review committee. And speaking of content, just like elsewhere in the world, each country has its own restrictions in relation to content. China also had its content restrictions. But just to be clear, this is not just for AI, but also for all other kinds of online services. Essentially, you cannot use the AI to generate illegal output or illegal information, and you should put in place mechanisms to stop spreading undesirable or unethical content. In terms of data security, there's no exception for AI. By that, AI still need to be subject to those important data security regulations and the laws. For example, cybersecurity law, data security law, as well as personal information protection law. But in terms of AI, there's some special additional requirements, including things like you need to use data and model from legitimate sources, and you cannot use IP infringing content, and you need to ensure that the data that you use is accurate and objective and diversified. There are also some specific requirements about the data labeling. You need to have some internal control and the internal rules in relation to data labeling, and others. The last page, it's China's position paper issued in 2022, and it summarized Chinese government's methodology in relation to regulations of AI. And as you can see, that's 4 topics or 4 themes, including regulation, research and development, and use and international cooperation. I'm not going to read this because of the limited time, but among others, China opposed efforts to obstruct the technological development of other countries. And China does call for international treaties and governance framework on AI, or a global collaboration in the regulation of AI. So that summarize. Oh, yeah, the last page. Okay. Some quick takeaways. China had developed a relatively comprehensive regulatory framework for AI. I'm not saying China's regulation will stop evolving. It will certainly evolve as the technology evolves. And the main aspects of the regulation include security assessment and regulatory filings for certain in-scope algorithms, and the ethical review of AI is also an important aspect of Chinese AI regulations. And the last but not least, China does call for global cooperation in AI governance. And thank you.
Thank you, Samuel, for sharing us on the AI regulation in China. I know the time is already over 4 o'clock. Do we still have time for Q&A? Okay, how many minutes do we have for Q&A? 20 minutes? Sure. Okay, 50 minutes. All right. Okay. All right. Thank you for enduring with us. Let's give another round of applause to our distinguished speakers. Now I will open the floor for questions. Can I ask the first one? I know there are interesting hands being raised already. We heard much from the speakers on different jurisdictions adopting different approaches in regulating AI. I want to ask the panel speakers, what do you think is the best approach to regulate AI? Especially, do you think you will see some kind of a harmonization between different jurisdictions? Just any panelists, please feel free to jump in.
I'll jump in and take this first. I'll catch the hot potato and then I'll pass it on when it's hotter. I think that it's, like I say, I don't think there's going to be much in the way of, it depends on your measure of harmonization is. I think that there's going to continue, as Mr. Okada said earlier, dialogue. For example, the G7 recent statement on generative AI. I think these sorts of things are very useful. I think that it's important to have dialogue between regulators all over the world and sort of, and large private organizations that are developing AI and researching AI. I think these are incredibly important steps. And I think that we also need to be aware that there will just be different regulatory design parameters that will have a greater or lesser importance in certain jurisdictions. And so the EU having spearheaded the GDPR and sort of, this essentially it was sort of a state change in terms of the way that data privacy regulation is addressed worldwide, has now sought to spearhead this movement in relation to AI, and not everyone in the world agrees with that. And I think that, I do have some sympathy with those governments and regulators who are adopting a wait and see approach because they don't want regulation to front run innovation, and believe that the existing framework of laws is sufficient to protect rights and interests as it is. And maybe they will, evolve. They will evolve with the technology and revisit that issue when it comes to it. So I think that so I'm not dodging the question. I believe that the wait and see approach, definitely has some merit to it, and I think that seems to be the dominant approach in the Asia Pacific region at the moment.
Thanks, Dominic. Anyone else?
I'll chime in. I guess, for us as industry players, right, it would be important to have some sort of global governance framework that, really include all the different jurisdictions. And at the core of the framework, for us, it is important that AI must always be under human control. And we need to have safety measures like a safety break to prevent harmful use of the technology. And so I think, echoing what Dominic was saying earlier, we'll see a patchwork of, how to rely on existing laws. We'll be developing standards. And you can imagine that some of these standards will be easy to achieve. Like, you would expect standards on how to use AI on biochemical weapons or, targeting CII, critical information infrastructure, that kind of standards. But at the same time, I think it was Professor Chanda who mentioned this morning that it's also important to incorporate local rules because you have to respect the local culture and the societal views on how to use the AI. So there's no easy answer to that. And I think that's what everyone is trying to work on.
Thanks, Winnie. Anyone else?
I want to echo what Winnie mentioned about harmonization of the rules, even though we're already seeing some signs of fragmentation in this space, because we're really seeing an array of different AI initiatives, governance initiatives around the world. And it's really concerning because for people that are launching AI products, it's very confusing. I mean, you might have different rules around the world, like in different jurisdictions. So I think harmonized rules at the international level, it's something that I think is really important. And I think another thing I think it's important is what we call a multi-pronged approach, because at the top you may have like governance regulations or hard law or guidelines, but I think there are certain issues like technical issues that needs to be dealt with by industry body, with government and policymakers. For example, one risk that a lot of people talk about is really misinformation, like the ability of generative AI being used to generate content which is not true. And industry are very active in discussing about how to researching and also looking into how to address this. And one solution is watermarking, invisible watermarking that's being put on audio or a piece of content that for example, if it's something that's generated by generative AI, we put a watermarking on it. And if it's being shared in third-party platform, for example, like WeChat, their platform can still pick that up so that their platform knows that this content is generated by generative AI. So we need industry standard for this kind of watermarking. So I think there's quite an urgent need for this kind of like industry-led and also very technical issue. Really, I think these are things that are not the traditional policymakers will focus on, but they're very important in addressing a lot of the risks that people talk about, and also like transparency. What kind of transparency? I think these are also things that if you want to move fast to address the risk, put it in standard. Working policymakers and industry come together. And also because I think generative AI is quite technical, honestly. And I was a former regulator, and I know you really need a lot of you really need technical expertise if you want to really regulate well in this space. So I think this is an area that close collaboration with industry, academics, policy regulators is important, and like red teaming standards. So these are things I think what I would call as a multi-pronged approach. You don't wait for just a draft law to go through the legislature, but it's something that should all the multi-parties should come together and work on something. Yeah.
Thank you, Raina.
I agree with all other panelists. I just want to add one additional perspective. Probably not having a harmonized or international agreed, set of rules, AI rules, is probably the best. But I don't know. I said that because this is not a new topic, right? When we talk about IPR regulations, when we talk about the international treaties, we talk about the international rules. But eventually, each country has its own set of IPR rules, etc. And you know, some of the legal dependence may exist in some jurisdictions, but may not exist in other jurisdictions. And there are reasons for that, right? You know, apparently the lawmakers in different jurisdictions, they debated and decided to take that approach. That approach, you know, I said they have reason to do that. And China, my personal observation is that, you know, China is a true believer of diversified approach. You know, they really respect other countries' own development paths, you know, in terms of social life, in terms of lawmaking process, etc. And you know, at the same time, China has its own ways of you know, it's making its own regulation, etc. That's, you know, my random thought on this issue. I'm not providing any answer.
Okay, thanks, Samuel. Okay, let's move on to the audience. Oh, sorry. Okay.
I just have one thing. You know, this is with my intellectual property hat on as well. I know there's maybe some IP practitioners, is that, you know, you have international frameworks and treaties such as TRIPS for copyright, but then, well, for various kinds of IP, but then you have differences between the, you know, regulatory approach or the legislative approach under specific laws. For example, you know, Singapore in 2021, when it was looking at its amendments to its copyright bill, came up with the computational data analysis exemption, which was perceived as friendly to, you know, to sort of web scrapers. And so it could position itself within, you know, in compliance with TRIPS and with sort of the generally accepted principles regarding, you know, intellectual property protection, and yet create its own, you know, its own environment potential for, you know, regulatory arbitrage. And then the same thing with the OECD privacy framework. You know, privacy laws might accord to the same principles, but then have, you know, regional divergences. And I think that's common.
Thanks, Dominic. So the lady there.
Oh, thanks. Hi. My question is directed to the representatives from the 3 leading AI firms here. From what I understand, your companies have done a lot to ensure, you know, transparency, honesty, you know, safe AI. And in the ideal scenario, do you prefer that, you know, just government just leave us alone and then we can self-regulate, or within our industry, you know, we can create some sort of industry alliance? Because, you know, as Raina just mentioned, right? I mean, some of the stuff is very technical. I mean, even policymakers may not know what's going on, right? I mean, would that be the ideal approach? Because what we are seeing in the United States is actually there's company like OpenAI going to Congress, they lobby for regulation. And then people were speculating they're doing that in order to increase entry barrier for competitors. But they come back and say, look, I mean, we just want to raise the industry standard because we don't want a bad apple among us that, you know, ruin the whole reputation for the whole industry. So I'd like to hear the take from our you know, 3 panelists here. Yeah.
Maybe because there are more questions, so maybe we hear all the questions, then they will answer together. Okay, here.
Oh, yeah. Okay. Thank you very much. Just very quickly, this morning when we were talking.
Oh, tell us who you are first, maybe.
Okay. Yeah, my name's Gable Zheng. I'm from the New Zealand Chamber of Commerce. This morning we were talking and asking the regulators about enforcement. So in the context of what's just been spoken just now, and that yourselves seem to recognize the technology risks, the compliance risks, and as industry players, what's your view towards actually enforcement as such? Because the regulators at this point in time aren't thinking enforcement. I think that may be the way to go, to actually give some teeth to whatever the regulations or the standards might be, or might end up.
Okay, thank you. There are questions there?
My question is about the representative of Meta primarily. Talking about openness and models, a lot of people are, you know, really happy to have really big models more in the open so that they can look at some of the social issues that are part of them. And one of the big issues that's obviously coming up is issues of copyright, but other rights that might be in models and input. And so my question to Meta is why the Llama 2 license has a very strange clause in it that means if anybody brings any claim against Meta that relates to copyright of the output of models or any rights that relate, they think they hold as an individual regulating the output of models, the Llama 2 so-called open source license is immediately rescinded from them. So it just feels like a very counterproductive part of license when we're in a point where we should be promoting that kind of research for understanding, whereas this license, as a ratchet clause that immediately puts them in copyright infringement and liable to lawsuits back from Meta.
Okay, thank you.
Hi, Ronnie. Just a very quick question for Dominic, please. In your studies of the various laws throughout the world, what differences have you found, for example, in the definition of AI, and how significant are these differences?
Okay, thank you. I think it's all the questions, right? Or more? Okay, let's start answering then. The first one on an industry alone approach. Yeah, I'll start.
Yeah, I think for Microsoft, we are in the same position as OpenAI, that we do think that regulations are required to govern the use of AI. I think it's fair to say that this is still a developing technology. There is a lot of unknown attached to it. And so, but at the same time, we realize that it's a very powerful tool, right? So I guess as an industry, we talk to governments and regulators to figure out what's the best approach. We do think that at the end of the day, you need to have a certain framework, a regulatory framework to govern the use. And I think that is also important from the user's perspective, that will give them more trust and confidence in the use of the technology, knowing that the government and other relevant stakeholders have engaged into that conversation to make it safe for use by the public. I'll stop there.
For Meta, we also support efforts to develop harmonized rules. So in the US, so the US, the White House, they released voluntary commitments, and Meta, and along with a few very big AI tech companies, will also openly support those commitments, voluntary commitments. So our view is that we support that there are governance around the use of the technology, because as Winnie said, I think if there's no rules, I think for adoption and also for users, they will not be sure whether what kind of measure is being built into the product before it's launched. So I think if there is some kind of regulation, actually it would actually help people's confidence and also facilitate, and also it's helpful for adoption of new technology as well.
Thank you. Thanks for the question. I think in my personal view, regulations are going to be good for AI, regardless of whether it's from a development perspective and adoption perspective. I think with the birth of generative AI, we all understand that AI could be super powerful, and so if it's being falling into the wrong hands, or if there are bad actors, there could be quite a bit of a catastrophic effect. And so in a way, I think regulations will be good to set up the framework such that AI development will be used in an ethical and responsible way. But I think regulations has to be balanced. It cannot be like a very strict sort of set of standards, because you look at technology development is actually progressing really, really quickly, and as lawyers, we know that laws are oftentimes lag behind technical development, and so we do want to see that there are a very solid framework on how AI should be developed, but that it should also create a very a space for us to continue to ethically develop AI. We think that AI should be used for tech for good, for the good of humanity. And going to one of the questions on industry players communications, I think industry players, regardless of whether there are trade secrets and whatnot, when it comes to compliance, when it comes to what's good for the community, for humanity, we're all in the same boat. And so industry players do communicate with each other There are industry groups in this space, and we oftentimes speak with regulators as well on how or we think AI should be regulated. I'm going to address the second question, if I may, on enforcement as well. Whether regulator we see that enforcement would be a good tool for regulators. I think in this morning's session, it's imperative that enforcement is going to be one of the tools that regulators are going to use when it comes to laws. I mean, laws are there to be enforced. And so, but I think the way we should be looking at it is there should be a lot of collaboration, discussions between industry players and regulators. There should be a lot of education process for industry players to understand what the regulators' concerns are, so that we can produce meaningful solutions to address their concerns. Enforcement should be used really at the as last resort. So say, for example, if there are really there are bad actors who disregard any integrity of the laws, then surely enforcement will be a powerful tool for regulators. But I think it should only be used as last resort.
Thank you all. Anyone else on the enforcement side to make comments? Okay, if not, then I'll move on. The third question for Raina.
Maybe I can also share a little bit on the enforcement question. I think Steve alluded to it this morning about there's this paper about regulatory approaches, like regulators, whether they take enforcement. I think there are different schools of thoughts. Some regulators maybe definitely enforcement is one of their tools in the regulatory toolbox. But there are a lot of the regulators, they may not have a lot of resources. So actually, enforcement actually could suck up a lot of the resources for regulators. I'm not saying that they shouldn't be enforcing, but it's a reality. So I can understand why, and from my prior experience as a regulator, and that's why some regulator, they would, especially for emerging technology, when you don't have the law, or how do you apply the law to this? How do you apply the law into this new scenario? It's very unclear. So some regulators maybe their approach is to try to issue guidelines like what the Singapore has done. They try to work with the industry to give them prior guidance, because the goal is to protect the privacy, to protect the people, to protect the consumer rights and interests. So their approach is to give guidance and to work collaboratively with industry to make sure that, because the goal is to want the industry to comply, to do the right thing. So I think that's one approach that is on the table, and some regulators are favoring that approach. But of course, I think some regulators may have a different approach. They think that, well, the regulators' mandate and also public expectation is that they will take enforcement action and see blood. I would say crudely, like, I mean, regulators, they also have to be accountable to their constituency. So I think it's matter. I think I think it's a company of our size. We don't have a choice, right? It's whether we want. It's not something that we say we want enforcement or not, but it's a matter like some regulators. I think everyone has their own constituency, including regulators. So some, they would think that, well, I have to take action. I have no choice, and this is the best course forward. But some, they think like, for some regulators of some country, they're small and they rely on foreign investment, or and they know that the best outcome is not to use up the whole budget for the year to fight one case, but rather to work collaboratively and get to the outcome that they can accomplish. So I think, to us, I think of course, we would love to work with regulator collaboratively, because we want to comply as well. But there are times when there are interpretation issues like GDPR. And I think, well, we hold different views, and I think there are certain issues that regulators feel that we need to see you in court. I mean, I think it's just a fact of life. So that's my view on enforcement. It's not something that we can choose. It's not something that, but I think this is just, if you have law and then enforcement is a potential risk or potential potential that we will be facing. But I think we are committed to comply with the laws that apply to us.
Thank you, Raina. Do you want to address the question on the Llama 2?
Yes, but I don't think I have. I don't think I know enough. Why? And honestly, I don't even know that clause exists. And thanks for flagging that. Maybe I can do a little bit of digging around and I don't have the good answer to your question right now, but as some of you may already know that we are already being sued by people for copyright infringement for our large language model. And my lawyers won't like me to be answering questions, discussing this publicly, because I don't know whether there will be someone from the plaintiff firm. But I would say, like, for technological advancement, there's always tensions, or there's always, when you see technology changes or advancements, there's always some brings questions about whether the law apply to it and how does it violate the existing law. So I think this is something that we're exactly seeing here in generative AI. The copyright law is very much front and center, and we're in the middle of it. And for us, we are committed to respect protection of IP rights, because we think it's good for creativity, good for innovation. So the protection of IP rights is very important. But I think what is on the table right now is really whether we can use the data to train the model. So this is something we will continue to monitor very closely, and I think this is something that we probably, one of those issues that needs a determination from the court. Yeah.
Thank you, Raina. The fourth question, Dominic.
This was the question on the definition of AI. Yeah, I mean, I think that even though I believe that the EU AI Act and the California Consumer Privacy Act, or the latest legislation, was moving towards the OECD definition, I think that there is a lack of harmonization about what we're talking about when we're talking about AI. And I think it is a problem, because then, you know, is simple, you know, are you talking about a kind of a computational analysis being, you know, falling within the definition of artificial intelligence? Or does it fall outside? Is it, you know, considered something else? Is someone who works with statistics suddenly and uses a computer to do that suddenly within the definition of AI? I think it's one of those areas that you're right to call this out, where there is a lack of clarity, and it would be good to see some harmonization and some sort of general adoption of more sort of uniform standards and definitions. And so definitely I would like to see that. And I think that there's awareness as well of that. And I think it's just because we're at such an early stage and it's such a rapidly developing technology. I mean, and, you know, we've been using artificial intelligence for years, but then the kind of the newer, I suppose, forms and instances of artificial intelligence can be hard to capture in words. So I think there needs to be more discussion about this and alignment.
Thank you, Dominic. I think this concludes our session, but Professor Sun, when will the second one, the next one start? Or do we have a break or no?